Judgment in the matter of Project Blue Limited versus Commissioners for Her Majesty's Revenue and Customs.
Lord Hodge will explain the decision of the court.
This appeal concerns the interpretation of statutory provisions in the Finance Act 2003, which introduced stamp duty land tax, which I'll call SDLT. In particular, the appeal is concerned with the provisions of that Act which provide exemptions for transactions involving Islamic finance in order to create a level playing field with the exemption given to conventional Western funding arrangements involving secured borrowing. In 2007, Project Blue Limited, which I will call PBL, contracted to purchase the Chelsea Barracks in London from the Ministry of Defence. PBL obtained funding of 1.25 billion for the acquisition and related costs from a Qatari bank, which I will call MAR. That funding complied with the prohibition in Sharia law against the payment of interest on borrowed money. The transaction was completed in January 2008. The Sharia-compliant arrangement, known as Ijara, involved 4 related steps which were implemented at about the same time. First, PBL purchased the barracks from the MOD. Secondly, PBL sold the barracks to MAR, which thirdly leased them back to PBL. And fourthly, MAR and PBL entered into put and call options which required or entitled PBL to repurchase the freehold of the barracks. PBL lodged a tax return in which it claimed that it was due to pay no SDLT on its purchase of the barracks from the MOD because of subsale relief under Section 45(3) of the 2003 Act. MAR also lodged a tax return asserting that it also was due to pay no SDLT in reliance on the relief made available to Ijara Finance under Section 71A of the 2003 Act. And similar relief was claimed for the lease of the barracks to PBL. As a result, the parties claimed that nobody was liable to pay SDLT on the transactions. Now, HMRC challenged PBL's return and in a closure notice claimed £38.36 million was due as SDLT. PBL appealed this decision and HMRC successfully applied to amend the claim to £50 million in order to reflect the larger sum, the 1.25 billion, which MAR had provided. PBL's appeal failed. PBL then appealed to the upper tribunal. It altered its position before that tribunal to argue that MAR should have been liable for the SDLT and would have been so liable but for the expiry of a time limit. It was argued that MAR was not entitled to the relief given for Ijara Finance under Section 71A because, on a proper understanding of the related provisions, MOD was the vendor of the barracks and not PBL. The upper tribunal did not agree and found that PBL was the vendor, but PBL succeeded on its appeal to the Court of Appeal, which held that the vendor was MOD, not PBL, as a result of a disregard of the contract between MOD and PBL in the 2003 Act in Section 45(3), which meant that PBL had no chargeable interest when it contracted the subsale of the barracks to MAR. HMRC appeals to this court. The principal question is whether PBL is due to pay SDLT of £50 million arising out of its purchase of the barracks from the MOD. This court, by majority, allows the appeal. The case principally concerns the interpretation of Section 45, which allows for subsale relief, and Section 71A, which provides relief for Ijara transactions. Like the upper tribunal, the majority concludes that PBL was the vendor under Section 71A2, with the result that MAR's purchase of the barracks from it was exempt from SDLT. The combination of subsale relief, which exempted the sale from MOD to PBL, and the Ijara relief, which under Section 71A meant that the transactions would have escaped tax but for the anti-avoidance provisions in Section 75A, which Parliament introduced into the 2003 Act to counter tax avoidance by schemes which sought to combine subsale and other reliefs. The majority interprets Section 75A as applying to the series of transactions, with the result that there is deemed to be a sale of the barracks by MOD to PBL at the price which MAR paid for them, namely £1.25 billion. The court also rejects PBL's human rights challenge, which alleged discrimination against those of Islamic faith. Accordingly, PBL was and is liable to pay £50 million in SDLT. Lord Briggs dissents, holding that the transfer from PBL to MAR was not exempt under Section 70A2 because PBL was not the vendor for the purpose of that section. He argues that Parliament could not have intended a lacuna by which nobody was liable to pay for SDLT on the transactions. The majority answer that by saying that the legislation introducing SDLT had contained a patchwork of provisions and that the existence of the lacunas was what Section 75A addressed.